Be ready. Start. The learned senior counsel who argued for the claimants contended that when compensation was enhanced by court, be it court of original or appellate jurisdiction for the land in the neighborhood of the claimant acquired under the same notification, such claimant also becomes entitled to receive higher compensation to his land by making an application under section 28A. In that behalf, the grant of higher compensation would furnish the cause of action even to the non-protester claimant to make an application under section 28A bracket 1 for redetermination. Payment of inadequate compensation provides him grievance to seek redetermination. Therefore, he is an aggrieved person whether received compensation with or without protest or omitted to pursue the right and remedy under section 18 or 54 or under article 136. The right to receive adequate compensation is the object of the Amendment Act as it was intended to relieve hardship of the poor or inarticulate claimants who receive inadequate compensation as stated in the Statement of Objects and Reasons of the Bill and the financial memorandum annexed to it. Therefore, whether a claimant received the compensation under protest or without protest, the moment the claimant of the neighboring land gets higher compensation, he also becomes entitled to make an application under section 28A for redetermination. Appeal is a continuation of the original proceedings under section 18. The limitation begins to run as soon as higher compensation is awarded either by the civil or by the High Court or by this court. Excluding the time taken for obtaining a copy of the judgment within 3 months thereafter, the application in writing should be made for redetermination. As the LAO is adjoined to redetermine the compensation on the basis of the enhanced award of compensation made under section 26 by the court after September 24, 1984 and award made under section 11 even before coming into force of section 28 would also be liable to be reopened. Each or successive awards or decree of the court, original or appellate jurisdictions would furnish fresh cause of action to those who had not sought reference under section 18 or appellate remedies. An unsuccessful applicant for reference under section 18 who did not avail of appellate remedies cannot unjustly be denied payment of compensation on parity with his affluent neighbor who had been given higher compensation, be it under section 26 or 54 of the Act or article 136 of the Constitution, etc. However, subsection 2 of section 11 empowers the collector without any further inquiry to make an award in terms of an agreement where such agreement is made by writing by persons interested in the land on appearing before him. The award shall be made within the period of limitation fixed by Section 11A. That award required to be filed in his office and shall be final and conclusive evidence between the collector and the persons interested as regards matters specified in Section 12. When the award is made, the collector shall give immediate notice to such of the interested persons as are not presented personally or by their representatives. Section 31 mandates the collector to tender payment of the compensation awarded by him to the persons interested thereto according to the award and to pay them unless prevented by one or more of the contingencies enumerated in subsections 2 and 3 or the later subsection or by reason of a reference made under section 30. By operation of second proviso to subsection 2 provided also that no person who has received the amount otherwise than under protest shall be entitled to make any application under section 18. On making such payment under section 18, when the application has been made within 6 weeks from the date of the collector's award by the interested person present or represented before the collector when the award was made, and in other cases within 6 weeks from the date of the receipt of the notice from the collector under subsection 2 of section 12 or within 6 weeks from the date of the collector's award, whichever period shall first expire. Under section 16, unless possession of the acquired land was taken under section 17, the collector shall take its possession and such land thereafter vests in the state absolutely free from all encumbrances. The person receiving compensation under protest because of the first proviso to section 31(2) gets right under section 18(1) to make an application in writing to the collector requiring him to refer the matter to the court for determination of his claim for compensation, and the collector LAO in such an event is enjoined to refer the matter with the required particulars. Court has been defined in section 3 clause D to mean principal civil court of original jurisdiction unless the appropriate government has appointed a special judicial officer within specified local limits to perform the functions of the court under the Act.